In July, two different Ohio appellate courts decided two different cases dealing with undue influence. Essentially, the plaintiffs felt that due to undue influence, their inheritances were reduced or eliminated. Could your heirs undo your estate plan? Let's see what those cases decided. The first case is called Poston versus Love. In this case, the decedent left most of her assets to one of her sisters and to her daughter. She left her disabled son a much smaller amount. After her death, her ex-husband, whom the court indicated hadn't even had contact with her son for 17 years, became the son's guardian and argued that the sister had unduly influenced the mother to leave the daughter money instead of the son. So what happened? On appeal, the court decided that the allegations the ex-husband made were insufficient to prove undue influence. Although he testified that the sister was advising the decedent before her death, he admitted that he really wasn't even familiar with what they discussed. Basically, the ex-husband argued that the distribution was unfair. Bottom line is that not liking the outcome and simply thinking it should not be the outcome isn't enough to improve undue influence. You need to prove something more. That only makes sense. So what happened in the other case? Here's a very brief overview. In this case, Kiefer versus Kiefer, decedent and his wife Kim began dating in 2001. The decedent had a child from a previous marriage. Before they married, decedent signed a will leaving his home and his family farm to Kim. They married in 2010, and decedent also made Kim his beneficiary on many accounts. When he died in 2013, his son from a previous marriage challenged the will and the beneficiary designations. One of his arguments was undue influence. Essentially, he argued that his father trusted and confided in Kim more than anyone else. He also used Kim's testimony that decedent would listen to her point of view and that she and the decedent would discuss matters together and make joint decisions. The court stated that that just describes any good marriage. Undue influence can arise in a marriage, but the presumption of undue influence does not arise solely based on the marriage. So, what do these cases mean to you in your estate plan? If you're updating your estate plan, make sure everything is documented, what you want to leave and who you want to leave it to. The execution should be formal in front of qualified witnesses who can attest to your competency. Ask a lawyer for advice to have the best facts and circumstances to avoid a challenge. On the other hand, if you're in a situation where you think your loved one was unduly influenced, do these cases mean all is lost? Absolutely not. But to prove undue influence, you need evidence. Evidence that can show the decedent was susceptible to undue influence, was influenced, and the outcome changed as a result. Proving undue influence is difficult, but not impossible. It really is all about the evidence. Still have questions? Use the information that's coming up next.
Call Solomon, Steiner, and Peck at 1-888-236-5173 for more information or to schedule a speaker for your organization. Or log on to www.ssnplaw.com.
Thanks for joining us. On next week's show, is taking a lump sum the sweetest deal? We'll add up the true costs. Then there's a treatment for heart disease that even some doctors don't know about, but we do, and we'll tell you all about it. And don't let the Grinch steal the value of your gift cards. We'll unwrap important rules. But until then, please, remember to make the most of your golden opportunities.
If you'd like to join our kitchen conversation, visit our website, www.goldenopportunities.tv. Like us on Facebook. Call us at 440-742-GO-TV or email us at kitchen@goldenopportunities.tv. We'd love to hear from you.
Golden Opportunities is paid for by Elder Productions.